Good afternoon, everyone, and thank you so much for taking time to join us today. We appreciate you taking time out of your very busy day. Today, our topic is everything you want to know about business associate agreements. And before we get started, just a few housekeeping items. You will see on the left side, there's a download file. You can find a few resources there that we'll refer to during the presentation as well as the presentation itself. Also, there is a Q&A pod. And if you have any questions, please feel free to type your questions into that box and we will answer them at some point during the presentation. Today, we are really fortunate enough to be joined by Adrian Senyszyn. He is a principal in Germer's Construction Defect, Cybersecurity, and HIPAA practice. Adrian represents clients throughout Texas and was recognized as a Texas Super Lawyer in 2021. Adrian's cybersecurity practice is focused in the healthcare sector, where he routinely advises practices and groups about privacy and security rules. He is often involved in breach notification processes and has advised a number of practices suffering catastrophic breaches in excess of 50,000 people. Adrian also defends practices before courts and administrative agencies such as the Office of the Civil Rights, U.S. Department of Health and Human Services, and the Texas Medical Board. Adrian is a frequent speaker of cybersecurity and HIPAA topics, and we are very appreciative of you being with us today, Adrian, and your willingness to share your time and insights with us today. And so at this point, I'll turn it over to you.
Thank you to the TMLT for asking me to speak on this topic. The genesis of this topic has come from many conversations I've had with clients about business associate agreements, and we're increasingly getting more questions about business associate agreements and some pushback from people we would consider business associates. So we thought it was a good one to put together a presentation for practices to understand the agreements themselves, and also talk about some of the advanced topics that we're coming across in these categories. The first poll that you had, there was a poll when you entered the presentation, and it was whether business associate agreements automatically expire after 24 months of their execution. And the answer to that question is no, they terminate when the practice or the business associate terminates it, unless the agreement has a time frame within it for termination. So your business associate agreement does not have an automatic termination period unless so specified in your agreement. And in almost every business associate agreement, we're going to put in language that allows the terms and promises and conditions of the agreement to extend beyond the termination of the agreement itself. And we'll talk about that a little bit more here as we get into the presentation. There is a disclaimer, and I'll let you read it. It's in the slides. Again, I have no interest or affiliation with TMLT. I'm just here at their request to provide you, the membership, with information about this topical category. We discussed the poll question, so I'm going to skip this slide. And the genesis of the business associate agreement and the topic of conversation we're going to have today really stems from the HIPAA privacy rule. And the HIPAA privacy rule provides federal protections for protected health information, PHI, held by covered entities, and it gives patients an array of rights with respect to that information. The privacy rule is intended to balance the rights of the patient with the ability of the practice to control and safeguard the information. Protected health information includes all individually identifiable health information, including demographic, data, medical history, test results, lab results, insurance information, payment information that could identify a patient and be related to their health care. A covered entity includes any entity defined under the HIPAA privacy rule that provides treatment, payment, and operations in healthcare. Covered entity includes practices, hospitals, clinics, psychologists, dentists, nursing homes, and pharmacies. And then last, a business associate is a person or entity that performs certain functions or activities that involve the use or disclosure of protected health information on behalf of a covered entity. And oftentimes a business associate creates, receives, transmits, or maintains protected health information. So our business associates typically are going to be billers, our vendors, an independent contractor who we hire to perform a function, IT providers. Your independent contractor might be a locum tenens doctor who's coming into your practice for a few weeks. Your lawyers and accountants who provide services when they're utilizing or accessing protected health information would also be business associates. It's important to remember that business associate agreements, it's not just this form document that we have out there and included in all of our policies and procedures. It's actually a legally binding and enforceable contract, and it needs to be drafted as such. We also have to give it the proper thought and consideration as if we were entering into a contract, because that's what it is. It's a binding contract. It's very important to have a business associate agreement in place because, one, it's a requirement under the HIPAA rules. It details the obligations of the parties, and it really allows us to enforce the agreement when we need to. It gives us a mechanism of enforcement with our business associate that we might not otherwise have. It also defines the rights and obligations of the parties, hopefully clearly, and would allow other parties like federal or state investigation agencies access to books and documents, both for the covered entity and for the business associate. It's also a risk management issue for the practice. And when I say risk shifting opportunity, we're talking about an opportunity for you to shift some of your liability and risk related to the storage and protection of health information to your business associate. Your business associate agreement can outline terms such as indemnification where you would shift those risks and costs if a breach occurred to a business associate. It's important to remember that if you don't have a business associate agreement in place and the government does find out that you're not compliant by having one in place, you're exposing yourself to further investigation and potential fines and penalties. You should always have a business associate agreement in place, ideally before work is commenced by your business associate, but you can also structure it in such a manner that you can have the effective date of the agreement start before it's executed, as long as you and your business associate understand you're following those same terms and conditions. If you don't have a business associate agreement in place, you should have one put in place as soon as reasonably possible. That covers all of your agreements with your various business associates. And that really entails your practice manager sitting down, making a list of every vendor, independent contractor who comes in contact with your protected health information, and then compiling a list of people who you need a business associate agreement with and putting one in place. Now, I had mentioned that business associate agreements are contracts, and this presentation we're going to get into some of the weeds of the terms and promises that are made within the agreement itself, but it's important again to a legal purpose for the contract, mutual assent of the parties, sufficiently defined terms to understand what the two parties are agreeing to. The contract needs to be supported by consideration, and you have to have legally competent parties. I often get questions about what is consideration. Well, consideration really is the payment of money and the services that are rendered. but it also includes the promises that are made within the business associate agreement itself. So the agreement itself, through the mutual promises, is a form of consideration that supports the validity of the contract. These contracts, if ever litigated, they're interpreted in accordance with the rules of construction. And the rules of construction is basically a framework for courts to interpret language within a contract. But one of the big takeaways is you want to make sure your language in your contract is as clear and unambiguous as possible. So as we start defining the work that's done by a business associate, we want to make sure the scope of the work being performed is clearly defined and that each of the parties understands what the other party is doing. It's also important to keep in mind business associate agreements oftentimes go hand in hand with a master services agreement or another kind of agreement with your particular vendor. So you want to make sure that your business associate agreement has language that it would control if there was a conflict between those two documents, and you want to be mindful of that other document when drafting your business associate agreement if you're not using the form. Business associate agreements, well, I guess HIPAA privacy, the HIPAA privacy and security rules are promulgated by statutory law. And the U.S. Department of Health and Human Services is the agency that helps enforce the privacy and security rules. And they have, in the statute, there are a number of requirements that should be included in business associate agreements. And I'm going to run through these requirements because these are all items that should be included in your business associate agreement for your practice. Every business associate agreement should include a permitted use or disclosure for the business associate themselves. Again, this is defining the scope of what the business associate can do with the protected information provided to it. There should be a statement not to disclose the protected health information other than as required under the contract or by law. We want to make sure our business associate understands what they can and can't use the protected health information for. You want to make sure your business associate has appropriate safeguards in place pursuant to the HIPAA security rule. In essence, we want to make sure our business associate is properly securing the protected health information. We also want to make sure they're complying with the HIPAA privacy rule with regard to any information that they're holding. You also want to require your business associate or define what uses and disclosures are not permitted, and also the terms of any sort of breach notification that you would require them. What's the time period that they need to notify you of an incident? What about investigation and the exchange of documents? You want to define that within your agreement. You also want to require the disclosure of protected health information to provide patient access. Now we have access that we need to provide our patients with to healthcare information and also the federal government if they ever were to investigate. One of the big pushes and emphasis of the U.S. Department of Health and Human Services over the last few years has been the patient's right to access their information. And they have a right to access information that may be within the covered entity's reach or held by the covered entity, but also held by the business associate. And don't forget, sometimes you hire business associates as vendors, and they may hire an independent contractor who helps them store data. You want to make sure your patients have the ability to access that data down the chain of contracts, whoever holds it. You also want to require the business associate follow the privacy rule with required language and references to the statute. Again, the business associate needs to be able to provide and make available their books and records in the event the Office of Civil Rights and the U.S. Department of Health and Human Services seeks access to that information. So we want a written document that says just that they would provide access to the federal agency if there was any sort of audit or investigation. At termination, we want to require the business associate to return or destroy any PHI if feasible. And the business associate should require any of the subcontractors down the chain of business associate agreements to have the same conditions in place that you require of your business associate. A good practice is to have, if there is a chain of business associates and you have a business associate and they hire someone, and that would be a second-tier business associate, and you're running down this chain, to have as consistent the terms within the business associate agreements as possible. It helps for a number of reasons. It helps for enforcement. It helps eliminate ambiguity, and it helps give you the practice adequate assurances that you have the correct information in place. And then you want to have a provision that authorizes the termination of the agreement in the event there's a material breach of the term of the contract. So again, the basic contractual provisions that should be included in your business associate agreement are the names of the parties, and not just the name that they're doing business as, but you want to include the full legal name of the entity. An adequate description of the purpose of the work done by the business associate, the effective date of the agreement. You'll have a section on definitions and references to statutory language, the underlying consideration, again, the obligations and activities of the business associate. So you have their scope, and then you have their legal obligations under the contract to you as the covered entity, the permitted uses and disclosure of the protected health information by the business associate, provisions for the covered entity to inform the business associate of privacy practices restrictions, and also changes. If you make changes to your practices, you want to have a provision that requires the business associate to implement changes your practice makes to its privacy policy. You also have a section on permissible requests, termination, and then the survival of the agreement. So here's sample language. We went ahead and included a sample business associate agreement that would allow you to have a nice form agreement to build off of. The provisions we're going to be looking at are found in that sample policy, sample business associate agreement. We've also included a business associate agreement checklist and a sample business associate agreement policy. The policy would be in your HIPAA policies and procedures. Anytime you make a change to your HIPAA business associate agreement, you might be making a change to your HIPAA policy and procedure or updating it. Remember, when you make a policy change, you want to make that policy change in writing, and then you want to make sure it's reflected in the different documents where it's applicable. So in this sample, you can see we have the effective date referenced, and the effective date in this business associate agreement is dated at the bottom of the agreement, so we make a reference to it. We also have the defined terms of the covered entity and the business associate. That's where you would put the full legal name of the entity. For our forms and for consistency, we use a reference. So we'll have the legal name of the entity, and then we'll have just simply refer to covered entity or business associate throughout the rest of the agreement. It helps keep the agreement consistent and error-free. And then in the second paragraph, we have an underline where we would place the scope of services to be provided by the business associate. The last paragraph, you'll see there's a section that we discuss the consideration supporting the underlying agreement. This is just standard language that would go, and typically you find it in many different contracts that you execute. This is an example, and it's not a comprehensive example. A more comprehensive example is in the business associate agreement provided. But this is an example of how we would define terms within the business associate agreement itself to make sure we're capturing not only the correct terms, but the correct statutory references and meanings. We don't need to necessarily define everything within our agreement the way the statute does, because we can simply reference the statute and incorporate those terms into our agreement. It's an easy way to cut down on the length of our business associate agreement, but also make it very effective. And also show our intent being to follow the HIPAA privacy and security rules, and also our intent to follow, in certain instances, the Texas Health and Safety Code, Chapter 181, with regard to record privacy, and also the Texas Identity Theft Act and the defined term, which is sensitive information. So we might have sections with those definitions within our agreement. I did not include all of the language used in the various definitions. Again, you're going to be able to reference the sample business associate agreement for model language that you can build off of or revise. But this is a topical section related to obligations and activities of the business associate. So again, in each of these sections, we're going to be defining those obligations and activities of the business associate and how they handle the protected health information. Section 1.1 is the use and disclosure, unless not to use or disclose certain information unless permitted, to use appropriate safeguards in Section 1.2, to report inappropriate disclosures in Section 1.3. And the list goes on. And we're going to take a look at some of those sections a little bit later on in the presentation. One section I do want to point your attention to is the destruction and retention of protected health information and the return of protected health information. We want to make sure we have sufficient language that requires the business associate either to return the information or to destroy it. And if it's not feasible to destroy the information, that they would safeguard it and hold it according to the HIPAA privacy and security rules. So I always like to remind entities, covered entities, that we want to be sure that our business associates understand that their obligations extend to protecting health information, extend beyond the agreement and extend beyond the termination of the agreement. We want to have sufficient language and assurances in that they're going to protect that information that was viewed, acquired, or used even after the termination. Sometimes we want to make sure that we have an agreement that's clear that if they ever discovered information that relates to our patients after a termination, that they would protect that information as well. In the sample business associate agreement, there's a section on permitted uses and disclosures by business associates, and it specifically is in section 2.1, 2.2, and 2.3. Again, here we're trying to define a specific scope for the business associate in the agreement. And then Section 3, and I've added the language of Section 3 into this slide so we can review it together. These are permissible requests by the covered entity. I've spoken about that a little bit earlier in this presentation, but those permissible requests by the covered entity should include any limitations or changes in the practice's notice of privacy of practice. We also want to include changes, revocation, or changes in permissions that are made by the patient to the practice. And this section is intended to require the business associate to implement those kinds of changes as into its own protection of the health information. So, for example, if we have a cyber incident and we discover we want to ensure that our data is fully encrypted, and we have a policy change that not only our data should be fully encrypted, but the data held by our business associate should be fully encrypted. We have this provision that would allow us to make a policy change and then enforce it on our business associate through a notice process. Now, our business associate, of course, could say, well, there's not a possibility for us to fully encrypt our data, and we would have to work out a reasonable alternative to that, and then make appropriate changes within our policy that would reflect that our business associate can't fully encrypt the data, but in lieu of being able to fully encrypt data, we have taken and implemented the following security measures in place, and our business associate has agreed to implement all of those changes and measures. Another example, and this is an example for patient access and also patient limitation, is when a patient wants to restrict the use of their data, and this may be a patient asking that their data not be used for any marketing purpose. I've come across this issue with practices who oftentimes you might use an image as either educational use or marketing use, and they ask for the patient consent specifically for those purposes. If you have a marketing company that's a business associate, or another person who handles information who's a business associate, when a patient doesn't consent to the release of certain information, you want to make sure any changes specific for that patient are also implemented at your business associate level. That's important, obviously, because if there's a miscommunication and information is released that shouldn't be released, then the patient would be able to come back, make a complaint against the practice, allege a HIPAA violation, and potentially trigger an investigation either with the medical board or the Office of Civil Rights. Any restriction that you want to implement, this section would be used, again, to restrict your business associate from using data. So if you have a scope of work change that you want to implement with your business associate, this would be a section that would allow you to implement that scope of work change. So again, we want to make sure your agreement with your business associate allows you to make changes, reasonable changes, and implement limitations. Another area that comes up, and it's a tension between the practice and the business associate, is investigation of an incident, if there's a HIPAA incident and a potential HIPAA breach, especially when it involves a business associate. So there's a tension between the practice and the business associate in a scenario where the business associate is the entity that is potentially responsible for the breach or the incident, and how the transfer of information and notification goes back and forth between the business associate and the practice. To step back a little bit and just have a little HIPAA 101 training, whenever you experience a HIPAA incident, the practice is required to investigate. It should document that investigation. At the conclusion of its investigation, it should make a breach determination. If there's a determination that a breach occurred, then the practice would be required to notify patients, and it should mitigate any harm to patients and also implement corrective action as soon as reasonably possible. This same principle needs to be applicable to your business associate, and one of the concerns along with implementation of that principle is we want to make sure our business associate is implementing the changes and corrective action that the practice sees fit, not that the business associate sees fit. There can be a disagreement between what the business associate thinks they should implement and what the practice thinks they should implement. That's an issue that should be identified and discussed in the business associate agreement, and we're going to look at some language later on about that. Whenever there's an incident, we have a duty to investigate as soon as reasonably possible, and we want to make sure that we receive notification from our business associate as the practice as soon as possible. Some business associate agreements I have seen put a time frame of 10 or 15 days. As a practice, you have 30 days to correct in order to substantially reduce your fine and penalties once you discover there's an incident and a potential breach. And you have 60 days to make a notification from the date of discovery once you discover there's an incident that turns into a breach. So every day that your business associate delays in notifying you about the discovery of an incident that may turn into a breach is precious time that you don't have to deal with the situation. So in this sample language, we put in 3 days for the business associate to notify the practice of a potential breach or incident under the contract. We also want to be careful to avoid language that says they will notify the practice in the event there is a breach. We don't want to be, as a practice, we don't want, again, our business associates solely making a breach determination on their own. And also, we don't want to learn about their breach determination down the line. We want them to inform us of any incident as soon as reasonably possible. So the best practice is to have the business associate be required to notify us of an incident or a potential breach that affects HIPAA under the privacy rule. We also want, again, our business associate to start mitigation efforts as soon as reasonably possible and corrective action so we can prevent that breach from occurring and reduce our chance at a fine or a penalty later on. So again, in this example, we have a 5-day time frame for the business associate to provide the notification. In the prior example, we had the discovery of a breach, which is 3 days. I think there was a little bit of ambiguity there. I need to look back at the example and the agreement. But again, back to the point, we want our business associate to be providing us with very quick information about the breach and also allowing us access to investigate a breach. Here's sample language about term and termination of the business associate. Again, the effective date of the business associate agreement, it remains in effect until the practice terminates it, or the time frame, whether the business associate agreement remains in effect until the practice or the business associate terminates the contract, or if the business associate agreement itself has a time frame in place for the agreement to be terminated. So we want to make sure that that term is correctly defined, and we also want to make sure we know when the effective date of the agreement starts. The termination should be required in writing. Oftentimes, some parties will put a specific manner and address where a termination should be made. It's the preference of the practice how they want to receive termination and where they want to receive the termination. There should be language within a business associate agreement that allows the covered entity to terminate the agreement at its own discretion, and especially if there's a reasonable suspicion that the business associate is improperly used or disclosed PHI. We want to give, since we're drafting from the perspective of the practice, we want to provide the practice with as much opportunity to cancel and terminate the agreement as possible. So we want to give the covered entity as much discretion to make a determination if the business associate has improperly used or disclosed PHI. We also want to establish the rights, duties, and obligations that shall survive the termination of the agreement, and then what to do with the data once the agreement is terminated. Be very careful when drafting the termination section of your agreement that you reference your master services agreement with the entity. You either want to make it consistent with that master services agreement and the manner in which the agreements can be terminated, or you want to have the provision within your business associate agreement that the terms and conditions of this business associate agreement control. You'll want to make sure you have all the parties listed correctly and all the signatures on your agreements correctly. So when you're examining both of those contracts, you understand which agreement controls for what provisions and what language. It's always a good practice to try to keep the termination language as consistent as possible in between the business associate agreement and the master services agreement. And I always like to have the provision for the practices protection that it would terminate that the provisions of the business associate agreement itself control. That way, we can always argue that the termination policy or the contractual promises under the term and termination in the business associate agreement control, and we understand all those terms. It also helps for consistency amongst our business associates to be able to use the same business associate agreement and understand how we terminate our relationship with each of those business associates. There's other miscellaneous languages you might include within your agreement. That would be whether the agreement, what is your choice of law? And it's important to remember, although we're following HIPAA rules within the agreement, and we might reference state rules within the agreement, we still have these rules of construction and contract interpretation with respect to the contract itself. So what legal rules are we going to implement in the event there's a dispute about between the covered entity and the business associate? And since we're a covered entity doing business in Texas, located in Texas, it makes sense that we would also want Texas law to apply to the interpretation of the contract and also be applicable in the event a litigation arose. So this would prevent you from having Florida law applied if you have a Florida business associate to any sort of a dispute between you and your business associate located in Florida. You can also implement a venue provision, which would put the exclusive venue somewhere in the state of Texas. So the concern there is just knowing what law applies and knowing where you would be in the event litigation were to ensue. You can also implement a arbitration agreement within the business associate agreement. But many of those provisions are going to be in your master services agreement. So if your business associate agreement is silent as to those terms, courts and different people interpreting the contracts will look to the master services agreement. So that's some of the tenuous, that's some of the nature of looking at the two different contracts and understanding what each contract says. And then last section is just notices that each party should give under the contract. So should the business associate agreement address the obligations of the parties requiring breach notification? Absolutely yes. And a tip is to require, and you could put this in your business associate agreement or in your master services agreement, but require your business associate to carry separate cyber liability coverage, and coverage that would be applicable to HIPAA incidents. This way they have adequate insurance coverage in the event there's a breach. Remember, if your business associate agreement is silent as to whether the business associate is responsible for notification of a breach in the event the business associate causes a breach, then the practice is going to be responsible. And what does that mean? Well, you might be responsible for the investigation costs, the notification costs to notify all the patients affected. If there's a forensic investigation cost, you might be responsible for that. Any fines or penalties, you might be responsible for those costs, those fines, those penalties. So when we think about the risk mitigation and risk shifting that we can implement with a business associate agreement or a master services agreement, we want to be thinking about what are the potential costs of a breach and who should be responsible for making a breach notification. So if we shift that responsibility to a business associate, that they would be responsible for the costs associated with a breach notification if they caused the breach, that they would be responsible for forensics costs, they would be responsible for any fine or penalty related to a breach. We also need to be thinking of how do we manage that? How do we manage the business associate and the notification and all of these other legal requirements to ensure, one, that the business associate does the notification and the investigation properly and in a manner that we feel is appropriate for our patients. And we're going to go into that we're going to look at some sample language, and there's some sample language in the business associate agreement. But we want to be able to, one, access the investigation documents, be in communication, and require the business associate to furnish us with documents and materials related to its investigation. And even in the event that we disagree with the business associate, we want to be able to control the determination that's made with regard to the breach. Again, we've talked about this, but the business associate should have BAAs in place with their subcontractors and anyone who might handle protected health information. And again, that's the chain of the business associate agreements going down the subcontractors and the different tiers of subcontractors that are used. So again, in this scenario, if there's a cyber attack against a IT cloud-based storage provider, and our record management company uses a cloud-based storage provider to warehouse records, and we have a contract with the IT company, and the IT company has a contract with the cloud-based storage company, we want to make sure there are business associate agreements down that line. And a best practice is to have a copy of all the business associate agreements down the line. And what does that entail? That entails the practice understanding who at the business associate is handling protected health information on our behalf, and are they hiring independent contractors for all or some of that work? And if they are, then you need to note it in your checklist if you have one, and then get the second tier business associate agreement for your records so you have a copy of it and you know who that person is handling the information. We're going to talk about some of the advanced provisions here and take a look at it right now, but we might require, again, choice of law, require that the document or the business associate agreement be amended only if in writing. That should always be included in any of your contracts. You don't want your contract changing unless a change is made in writing. You'll maybe include additional regulatory references. One that we'll look at is the relates to some new statutory provisions coming out. You might have a reference generally, and you always should, that if any law changes, then those new statutes are automatically incorporated into the terms of the business associate agreement. We've spoken about incorporating and making sure that our master services agreement and our business associate agreement are clear in how they define terms, and that the business associate agreement generally would control. When signing a business associate agreement, there might be a section on the counterparts of the signatures. We also want to have an integration that all of the prior agreements that have been discussed between the parties are integrated into the contract, and there's nothing oral out there. This brings certainty to the terms of the contract, and you'll often find this kind of integration provision within your master services agreement. There also might be a section on damages to discuss what kind of damages would be allowed between the parties. So in this example, we have potential language that we might implement that would require business associates to ensure their subcontractors create, receive, and maintain and transmit PHI, that they would comply with all the applicable laws and also have consistency within the agreements. I think I included this section. This is not, the second paragraph is not in the sample business associate agreement I provided, but it's a provision I've had requested implemented into the business associate agreements, and I generally don't have a problem with this kind of provision. This was a provision requested by a cybersecurity company, and what they wanted was to define clearly that a security ping or an attempt to get into a network by a hacker is not considered an incident and not considered a breach, and that they don't need to notify us every time there's an attempt or a ping to get into their network system. And the reason for that is hackers can set up bots and computer programs to knock on the doors of these different IT providers and the doors of our practices in an attempt to get in. And oftentimes they're running passwords and usernames, and they're attempting logins thousands of times a minute, if not more. If the business associate who's handling our IT and our security needed to notify us every time there was a ping or an attempted penetration into the network, they'd be doing it all the time. So this provision makes sense that they're not going to notify us of an incident occurring unless those threat actors make it past and into the door, and at that point, then they'll notify us that an incident had occurred. Another potential language is adding language that references new statutes, and an important statute that we should be aware of, and I think everyone is starting to get up to speed on, is the 21st Century Cures Act. And within that act, there is an emphasis on patient access to records and information. And also the 21st Century Cures Act is trying to prevent this habit of business associates and IT vendors from information blocking. Again, if you have a dispute with your IT vendor, or you're not paying your IT vendor and they're withholding or preventing you from accessing information, they are actively affecting your ability to treat patients, and they're harming the patient. What happens if you receive a patient request for records that's held by your IT vendor and they refuse to turn over the records because you haven't paid your bill, or there's another dispute between the two of you? We want to include as much language in favor of the practice that allows you to get that information even if there's some sort of dispute or non-payment between the parties, or that would allow the patient to go directly to the business associate and get that information. In reference to the 21st Century Cures Act, and that the business associate will not information block, which is a specific term of art within HIPAA, or being discussed right now and going to be implemented in the future, if not already, is a good provision to put into your business associate agreement. I like to include language about corrective action. If you have a HIPAA breach, the practice can substantially reduce its chance of a fine or a penalty if it implements corrective action within 30 days. I mean, it's within the provisions, and if you are a practice and receiving a letter of investigation from the Office of Civil Rights, it would say that. If you implement corrective action within 30 days, you can substantially reduce your chance at a fine or a penalty. We want to make sure we have a provision that requires our business associate agreement to do that same thing, and that's especially true whether the practice suffers a breach or the business associate suffers a breach. So if the practice suffers an incident affecting its database, and the business associate is an IT vendor who is intended to provide assistance, you might have language that the business associate is required to help with corrective action related to any incident suffered by the practice and any policy change. You might consider having that provision in with your IT vendor, that they would have to come in within a reasonable time period, but not more than 30 days, to make any sort of corrective action related to an incident or a breach. And again, if the business associate suffers the incident or breach, you certainly want to have a requirement that they're required to implement all corrective action within 30 days. It's just an additional safeguard, an additional risk management technique, but it's an important, a very important provision to have in place in case you get investigated by the Office of Civil Rights. Here's some possible language that would allow the entity or the covered entity the ability to investigate a breach that occurs with the entity's data that's in the hands of the business associate. You might include language that gives your practice the right to investigate and to look into what occurred. You also want to have the right to require the business associate to furnish you with information related to the incident. The second section is an interesting section. We've implemented this in at least one business associate agreement, and it gives the practice the right to analyze the assessments, conclusions, and determinations made by the business associate with regard to a breach. And in the event the covered entity disagrees with that determination, then the covered entity can notify the business associate. The business associate has time to analyze the information and make their own determination. And then the business associate would need to re-notify the covered entity about that additional determination that it's made. This is to get the dialogue going if the covered entity or practice is unsure or does not feel like the business associate properly made a breach determination or analysis. And then this is the companion section, which is 6.33, which would give the covered entity the right to proceed with notification in the event it disagreed with the determination made by the business associate. So we've had this issue come up in a few cases I've worked on where a business associate who's not very familiar with HIPAA and a breach determination and doesn't have legal counsel retained has an incident that occurs, makes its own determination, the practice learns of it and disagrees that they've done a proper determination, and actually believes that notification may need to be made. This provision just sets forth that the practice has the right to disagree and make that notification. And when you make a notification with the Office of Civil Rights, when it relates to a breach suffered by a business associate, you would actually go into a online web portal, you put in the practice's information, you put in a description of what occurred, and then it also requires you to list the business associate. So the Office of Civil Rights, as part of their investigation into the incident, they will end up investigating both the practice and the business associate, and typically they'll focus their investigation on the business associate. Now, if notification is made, my personal opinion is that the Office of Civil Rights won't penalize a business associate for a breach, not making the correct breach determination if the practice goes ahead and does it. What they will do, though, is penalize the business associate if they don't implement corrective action and mitigation, and they'll take a hard look at the practice to see if they sanctioned that business associate or even terminated their relationship with that business associate based on that incident. So you really want to make sure you have business associates who are familiar with HIPAA and, when possible, are willing to work with you on the issue of a HIPAA breach, because it's such an important issue, especially when a HIPAA breach occurs. It's very important to have the cooperation and coordination of the covered entity with the business associate and have your team in place and to be able to move forward constructively and not arguing about whether one person agrees with the other or who has the ultimate determination on those issues. So this is an important section. It really should be also, this slide doesn't have it in all caps. In Texas, to be conspicuous, you really want your agreement to have the language in all caps and bolded. We didn't do that in this instance just because it's on a slide and it's hard to read. But I'd like you to call you out to the middle section of this indemnification slide. Indemnification, again, is a way to risk shift to the business associate. And what we're doing is we're trying to make the business associate responsible for the payment of liabilities and costs that are suffered by the practice as a result of an incident. Indemnification clauses can vary, and there are statutory provisions that restrict indemnification in certain instances. When you get into this sort of drafting, I highly recommend that you have any indemnification provision reviewed by an attorney to make sure it's valid. In this indemnification provision, we have specifically listed investigative costs and expenses, forensics expenses, cyber incident costs, cyber breach costs, ransom negotiations and payment, notification costs, claims, suits, actions, proceedings, demands, losses, damages, penalties, fines, everything that comes out of those costs, because we don't want there to ever be a dispute as to what the practice, the business associate would be responsible for, especially if it's a large-scale cyber incident. And we actually have a cyber incident that has turned into a class action lawsuit. So those costs can be significant to a practice, especially if you exhaust your policy. And then there's some additional language at the bottom of it, which would capture, which would require the business associate to be responsible, even if some or all of the liabilities were caused by the covered entity. So if the ransomware made it through your system and your employee was the one who clicked on the phishing email, but it affected the business associate's information and the business associate didn't have proper measures in place, then we might have a catch-all there. There's some additional, we've talked about this section before, but governing law and conflicting terms, and you want to make sure your business associate agreement replaces all prior agreements. And then here's some slides on strategies that you can implement. I know we're out of time. I want to save time for questions, but these strategies are on the slide. One thing I want to say in closing is that when you get to your large EMR vendors, your large vendors of information, it's going to be extremely difficult, if not impossible, to negotiate those business associate agreements. They're going to have standard form agreements that they're going to require you to use, or they're just going to say, we don't want your business. In those instances, in your checklist of business associate agreements, you want to make sure you've identified all of your non-standard agreements, and that you maybe have a list of some of the ways it varies from your agreement as a quick reference, and you want to have it tagged in your notebook as a non-standard agreement. And I'm going to go, you should have your HIPAA policies and procedures are separate from your business associate agreement, so you should have a policy as it relates to business associate agreements in your HIPAA policies and procedures, and we have a sample one for you today. So we made it through a lot of material, and I'm going to go ahead and open up the floor to questions that you all may have.
Thank you, Adrian, for presenting this very important topic for everyone today. Just before we take a couple of questions, just a few reminders. You may still download the resources in the download files pod in the lower left corner. The easiest way to do that is to click on the three dots in the upper right corner of that pod, and you'll see the word download all. Click on that and all the files will download. You can still submit questions, and we will try to get to those in just a moment. If you are wanting CME, your CME evaluation is very important to us, and we will be launching the CME evaluation. It will be in your browser when you close the program. If your browser opens in front of the current program screen, just simply minimize your browser and you'll be back at the webinar. So, Adrian, we have a couple of questions. The first is, could you please confirm that a business associate agreement does not have an expiration date?
Yeah, if you don't put an expiration date in, then it's going to just renew according to your underlying agreement, and it won't have an expiration date. There is a rule of law called the rule against perpetuities, and generally that rule would say that your contract can't go on in perpetuity, but generally the structure of the business associate agreement isn't going to be to violate that rule. So it will go on as long as you contract for and it's silent. I would include language that says, this agreement is effective from the date entered below and until, and as long as the business associate agreement is performing services and functions unless terminated below. There should be some standard language out there related to just automatically continuing until the relationship ends.
So the next question is, if a pharmaceutical company won't sign the practice's BAA and want the practice to sign theirs, how do you recommend approaching this situation?
You can try to negotiate the agreement with their attorney, and some pharmacies or practices, or I guess business associates, will allow that course, and I have negotiated business associate agreements before. And if the business associate agreement, if the negotiation does not proceed with sufficient changes that you're comfortable with, then the recommendation is that you find another vendor who you can use that will put in place a business associate agreement that you feel comfortable with. Now, I've told you that some of the larger companies just won't allow any sort of negotiation to occur, and that may be true in this case. They just might not, the pharmacy company might not allow any variation in their agreements. A pitfall to be aware of is all of the issues that we've discussed today, ensuring that the agreement is not so one-sided against the practice that it places you at a degree of risk that you're not willing to accept. So you can try to negotiate it, and so the bottom line, you can try to negotiate it. Your options, if they won't negotiate, is to accept the agreement and just be aware of it, or to use a different vendor.
So there are EHR companies without cloud services and vendors that provide patient check-in software. Would the entities need a BAA with them?
Can you say that again, Kathy? I'm sorry.
Sure. There are companies or vendors that don't necessarily have cloud services that provide patient check-in software. Would the covered entity need a BAA with them?
Yeah, I mean, my rule of thumb and what I recommend to practices is anyone who potentially could come into contact with protected health information, you want to have a business associate agreement with them. Remember, if as a practice, you can't monitor all the time what information your business associate may or may not come in contact with. This is true of the physicians who need to be focused on treating patients. Your operations or admin person needs to be focused on running the practice and can't always be dedicating time to ensuring information going to a business associate doesn't have PHI. So if there's the potential that that person could come into contact with PHI, you want to have an agreement in place. There may be some exceptions where you don't have a business associate agreement in place with someone who performs a service for your practice. You want to note that person on your checklist and you want to note the specific scope of their work, and you want to do an analysis to ensure that they never come in contact with PHI, or there's not a chance. Remember what the rule says, that a business associate is defined as someone, a person or entity who might create, receive, transmit, or maintain PHI. So if they're maintaining it on a system, if they're working with it, they're coming into contact with it. I've had a lot of IT vendors who are computer security people who come around month to month to the practice, and they say, I don't need a business associate agreement. I don't handle the PHI. However, they maintain it in the practice's systems. They manipulate it. They help secure it. And sometimes there's the potential that they may access it. So I always tell those folks that they need to have a business associate agreement in place with their IT people and folks who are coming in and have the potential to be handling PHI.
Last question is, as a business associate, does the business associate need to provide PHI to patients?
Okay, so I think what you're asking is, if a patient requests protect their information from the business associate, do they need to provide it? And the answer is yes. And this is part of the Right to Access initiative by the Office of Civil Rights. And one of the things we're trying to prevent is information blocking and ensure patients have timely access to their health care records, because it's really related to their health and safety. So yes, the vendor would have to provide that information. The best way for that information to be provided is, or the best scenario how that information would be provided is, the business associate receives notification from the patient they want access to their information. The business associate at that point should notify the practice that they've received a request. Make sure the practice and the business associate are on the same page with the request for information, and then the information then would be released to the patient. Remember, in Texas, you have 15 days to release information to patients upon request. I think that rule is still applicable, although the federal default is 30 days, but I would follow the 15-day rule to make sure you're compliant with all laws. The most restrictive rule should be followed. And then document the release of the information after that. Now, if your question is that do business associates need to provide PHI just as part of the regular course, I guess it depends on what service your business associate is providing. I don't think this is the question, but if your business associate, if the function of your business associate is not to provide information generally to the patient, if they're not responsible for setting up a template or providing patients with information just directly from them, then generally you're not going to want to have your business associates providing or having any sort of contact or communication with your patients. You need to define that scope. Back to the original scenario that we discussed where the patient requests information from the business associate, the only other thing I would say is a better way that I would probably try to handle that is I would probably have the information coming through the covered entity in the practice. So they may request information in the possession of the business associate. The covered entity and business associate should coordinate the delivery of that information, and I, as a practice, would want to be the one delivering the information to the patient that is requested. But it can be done both ways.
Very good. Well, Adrian, thank you again for your your great information today, and thank you to everyone who was in attendance. We want to hope that we hope that this was informational and that you have a wonderful day. Again, if you have questions that come up later, you may always submit those to consulting@tmlt.org, and we will work to get an answer for you. Thanks, everyone.